Support of the Court's Remote Participation Bill, and I want to acknowledge the work of the Select Committee as previous speakers have done. And it's important to note a couple of points that not only the Minister made but also the Honourable David Parker made in his first speech in respect of this bill. And that is to acknowledge the substantial ground within the bill that we agreed upon, and then to acknowledge the real concerns that the Labor Party have and have expressed in their minority reports, and then I'd like to articulate the reasons why the government has come to its conclusion in respect to proceed with the bill in the way it has. And the first point is to note that in civil proceedings there is no real argument we should use audio-visual links and appearances by witnesses in respect of those as appropriate. And that is something that has been conceded, and there's been a movement towards that for some time, and it's been flagged. The second point to make is that in procedural matters, procedural hearings, these are matters such as bail applications, call-overs for trial, maybe name suppression applications and similar. Those hearings where no evidence has been called, again, there is agreement across the House that AVL, audio-visual link AVL, is an appropriate medium for a defendant to be able to appear in the court because they're represented, the arguments are well clear, there is no contest as to the evidence that's been given, or if it is, it's been well canvassed. And secondly, the point that the Minister made, and that is the safety issue, and then I guess lastly a cost to the taxpayer issue, which is no less an issue, especially in the matter quoted by the Minister of the transportation of a particular prisoner from Paramaribo to Wellington High Court for 2 procedural callovers. But the fact is that AVL is used in these procedural matters right around the world in all sorts of jurisdictions, sometimes with consent, sometimes at the discretion of the judge, but nevertheless all sides of the House agreed that that was appropriate. And the sticking point really was around substantive hearings, which are hearings where evidence is called, and the removal of what is at the moment a right of an accused to be physically present in the courtroom to a discretion where the judge has the ability to overrule a lack of consent and insist that the trial be heard by the use of audio-visual link. And I think that the point that the previous speaker made is that, or the thrust of this argument is that justice must not only be done but to be seen to be done, and the ability to see it being done should not be limited by wherever the camera casts itself. And the point that he made in respect of where the cameras are pointed during the course of a trial is actually quite a valid one. And in considering that, we have to think about the demographics of people who appear before the court as accused persons, and by far the majority of them struggle with literacy, struggle with understanding, struggle with the language that's used within a courtroom, struggle with an ability to be able to communicate with their counsel in legal terms, the ingredients of a crime. And in many concerns, they struggle with engagement with the legal system. We know that those people who end up going to jail are overrepresented in these areas, but also in areas such as drug and alcohol dependency, and about somewhere between 61 and 65% of them have mental health issues. And so we can see where the opposition is coming from in respect of the unfairness aspect, or the perceived unfairness of moving this step, the step that they deem to be too far. And the point was also well made that when you look around the world, actually no other jurisdiction is going where we're going. But at the same time, when we look at the criteria which are held within clauses 5 and 6 and 9 of this bill, then they are quite stringent. And Clause 5 really relates to general criteria for the use of audio-visual links, and and the decision maker, being the judge, then has to consider the nature of the proceedings, the availability and quality of that technology, the potential impact of the use of the technology and the effective maintenance of rights of other parties, of the parties to deal with the proceedings or to engage with the proceedings, to assess the credibility of witnesses and the level of contact with other participants. So we can understand that that is a good general parameter of the considerations. Then Clause 6 talks about specifically criminal proceedings. And so the judge has to consider not only those that I've just articulated from Clause 5, but also in Clause 6, the ability of the defendant specifically, and remember that this is exactly the concern that the opposition has in respect of this, the ability of the defendant to comprehend proceedings, to participate effectively in the conduct of his or her defence, and to consult and instruct counsel privately and access relevant evidence, and to examine the witnesses for the prosecution, the level of contact the defendant has with other participants. And so you can imagine then that that person who we all have already accepted is probably disengage his or her ability, but generally his ability to be able to engage with his counsel, instruct his counsel, and pass on the nuances and those sorts of things that he is picking up from the evidence given by a witness, and the difficulty that person may well have being able to communicate that during the course of the trial while the evidence is being given. For instance, in a cross-examination sequence of questions, for example, how well is the defendant going to be able to communicate the inconsistencies or the yes-buts that he may want to communicate to his counsel, and any adverse impression that may arise through the defendant or other participant appearing by means of AVL. And so looking through that list of criteria, one would hope then that a decision maker and believes, and the government certainly believes, that a decision maker taking all those criteria into account and making a decision whether or not someone was going to appear via AVL, it's a very, very high hurdle that they have to climb over to be able to make that decision. But then in Clause 9, it specifically talks about the use of audio-visual links in criminal substantive matters. So the criteria I've just referred to as the use of audio-visual in just procedural matters. So these are two extra significant hurdles that the decision maker has to come to and satisfy him or herself of before an order is made in respect of the use of AVL for criminal substantive matters. And they are considering the previous criteria, but also taking into account whether the parties to the proceedings consent or not. And so a judge thinking on that has to consider that very high hurdles before they go on to make that decision. It's important to note that when we quizzed, and the majority of the committee quizzed the officials in respect of how they came to this point, the point was made by the officials that they actually came to it from a mode of evidence approach, whereas the concerns of the committee were really around an access to justice approach, and a majority of the committee felt that we would have thought the officials would have come from it from that access to justice approach. I did have a conversation today with probably one of our leading counsel in this area and human rights or Bill of Rights type matters, and he made the point that the law is quite incremental, and a lot of the public don't understand quite how that makes and how that happens. A recent decision has been made where a complainant who has made a complaint to the police and given an interview to the police alleging a sexual abuse matter doesn't have to appear before the court to give evidence in chief at all or be available for cross-examination whatsoever, which is another step forward that has happened through the common law process. And so with the implementation of this bill then, you can conceive of a period of a situation, how remote that may be, and this is the opposition's point, that a defendant may well be charged with a crime where the complainant doesn't attend, isn't available for cross-examination, and the defendant isn't there either. Now, it's a significant step that has been taken. I can say that I am convinced that the work of the officials, the drafting of the bill has put in very, very high criteria. The government doesn't come to this position lightly and is aware of